Good afternoon. Welcome to another special edition of Good Lawgic. Earlier today, as many of you are aware, the affidavit in support of the probable cause was issued. Excuse me. The submission that was made in support of the probable cause for issuance of a warrant for a search of the home of Nick Rekieta was made public. And a lot of people question what this means when they're looking at it and trying to understand it better. In order to try and establish the legitimacy of the search warrant, we need to understand a little bit about Minnesota law as far as what it takes in order to establish probable cause. And perhaps this might give us some added insight as to the sufficiency of the facts alleged therein in supporting a claim of probable cause and the issuance of a search warrant. So before we actually look at the submission itself, I'm going to start by just pointing you in the direction of a certain Minnesota Supreme Court case, which has been cited over 250 times. So this seems to be the law in the state of Minnesota as it relates to these particular issues. Now, a couple of caveats. Number one, I'm not a criminal defense attorney. I've never been a criminal defense attorney. I've never been a prosecutor. I've never practiced law in the state of Minnesota. I'm simply an attorney who has some legal background in reading through case law and interpreting case law and sharing with you the law and facts as I best understand them today. It is certainly very possible that whatever law we assess today may have exceptions to it. This is the general overarching law. There could be very important cases which relate to this case, which may undercut the impact of what the case law I'm about to present to you presents. So, with that background, let's start by looking at the case of the state of Minnesota versus Theo Wiley. And this case comes from 1985. It's cited as 366 NW 2nd 265 from 1985. I'm going to skip past the facts of this case, other than the fact that in this case there was a contested search warrant, and we're going to jump on down to the case law itself. And this is the relevant portion that I think we can take from this case just to get a general understanding of how the Minnesota Supreme Court looks at search warrants and submissions that are made in support of a search warrant and assessing their validity when they end up unearthing evidence that could be rather incriminating to a potential defendant. So, in this case, State v. Wiley, back in 1985, Minnesota Supreme Court started by referencing a case of Illinois v. Gates, where they said the Supreme Court, Supreme Court decision, where they say the Supreme Court ruled that the presence of probable cause should be determined under a, quote, totality of circumstance test. And quoting from that case, they say the task of the issuing magistrate, the judge who's issuing the warrant, is simply to make a practical, common sense decision whether, given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. So, keywords that we're looking for here is, first and foremost, what we're looking at here is a totality of circumstances. This is given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge. The magistrate is required to assess who's giving this and what's their basis of knowledge when they are trying to assess this totality. A magistrate's determination of probable cause should be, quote, paid great deference by reviewing courts, which means that the decision to issue the warrant that was made in this case, as we're going to see by Judge Fisher, that the court is obliged, or reviewing court is obliged to give that great deference, meaning that the implication being, unless there is grave error that was made by the issuing magistrate, that the warrant would stand up. And a reviewing court should not review that determination de novo. De novo means anew, afresh, meaning sometimes when an appellate court is looking at a particular situation and the facts that were assessed by a lower court, the appellate court is directed to review it de novo, anew, as if it's never been looked at before, and say, okay, if this came to us, what would we say is appropriate here? That would be beneficial in this particular circumstance. If it were de novo, that would be beneficial to the defendant, because instead of we'd sort of set aside what the first judge said and say, okay, let's look at this and see what we think we would have done in this circumstance. That's what would be if they were reviewing it de novo. But the Minnesota Supreme Court specifically directs its appellate courts not to look at it de novo, but instead that they should pay great deference, not just some deference, but great deference to the finding of the magistrate court, in this case, Judge Fisher, and her finding that a warrant was appropriate. The Fourth Amendment requires only the magistrate had substantial basis for concluding that a search warrant would uncover evidence of wrongdoing. That's it. All you got to do. If you find the magistrate had a substantial basis for concluding that if you go in there, you're going to find evidence of wrongdoing, that's enough under Jones v. in the quoting Jones v. United States. In reviewing the sufficiency of an affidavit under the totality of circumstance test, courts must be careful not to review each component of the affidavit in isolation. You can't start saying, well, this piece here stinks, and then this piece here is not enough, and then this piece here is not enough. You can't look at them in isolation. You need to look at them as a group, cumulatively, together. Even if each component is judged unsubstantial, the components viewed together may reveal in the informant's tip an internal coherence that gives weight to the whole, citing Massachusetts v. Upton. Furthermore, the resolution of doubtful or marginal cases should be largely determined by the preference to be accorded warrants, i.e., what that means is when in doubt, we're going to lean in favor of recognizing the warrant as being valid. Now, again, this if you're reading this and you're sitting here hoping that a defendant will succeed in knocking out a warrant, this would give you great pause from thinking that you're going to find very many circumstances, if any, where a warrant is going to be deemed unjustified. It would have to be, you would think, a case where the magistrate was really grasping at straws and you can't piece together something. In that case, they'd say, okay, this was just really terrible. There was no reason for you to actually think they would find anything here. Perhaps in those circumstances, yes, a magistrate's decision to issue a warrant could be overturned. But this is the backdrop as to how the law stands in the state of Minnesota, and likely in many other jurisdictions as well. But what's only relevant for purposes of this analysis is the state of Minnesota when trying to assess the validity of this search warrant that gave rise to finding of various evidence that the state feels is incriminating. So with this backdrop and understanding of the law, we can now, and in this particular case, they use those principles to find against the defendant. That's referring still in State v. Wiley, and said that the warrant that was issued there was valid and justified. Now, given that backdrop, we can start to have a better appreciation for what we should be considering when we're looking at the submission that was made in support of an application for a search warrant for Nick Rekieta's home, and try and see, is that likely to withstand scrutiny if in fact it's reviewed by an appellate court? And again, it seems like from the law, there's a lot of dispensation that's given to the court that issues it. So unless we see grave error here, or unless there's some other little quirk of law that I'm unfamiliar with that might be unique to Minnesota or to the particular facts of this case that neither I nor you have any knowledge about, that could certainly change the entire analysis. Excuse me. I'm only looking at this from a 50,000-foot aerial view based on what the general idea of law is in the state of Minnesota and the general perceptions as to how they assess the validity of a search warrant, and now looking at what Judge Fisher had to look at the time that she reached her conclusion to issue a search warrant. So with that in mind, let's turn now to the facts that are being reported as what was set forth before Judge Fisher when she issued the search warrant. So, application for search warrant. I, Quinn Poplin, Pomplin, a licensed peace officer in the state of Minnesota, make an application to this court for a warrant to search the premises and persons described below for the property and things described below. I know the content of this application and affirm that the statements contained in this application are true based on my own knowledge or are believed to be true. I believe that the following described property and things, namely controlled substances, including methamphetamines, cocaine, or any other controlled substances prohibited by law and paraphernalia commonly associated with the sales, uses of controlled substances. Items that would show controlled substance use that would not qualify as legal drug paraphernalia. And that's what these are the things that he's looking to find is or at the premises and on the person described as presumably his name. The residence has a tar driveway leading east from 51st Street Northeast. The residence is 2 stories with a 3-stall garage. The main door is located on the south or southwest side of the residence. Nicholas Robert Rekieta, date of birth, located in the city township of New London, county of Kandiyohi, state of Minnesota. I apply for a search warrant on the following grounds. The possession of the property or things above described constitutes a crime. The property or things above described constitute evidence which tend to show a crime has been committed or tends to show that a particular person has committed a crime. The facts establishing the grounds for issuance search warrant are as follows. Here we go. What are your facts? Why do you want to access this property? Your affiant is a Detective Quinn Pomplin, a licensed peace officer in the state of Minnesota since 2009. He's trying to establish first his own credibility and his own understanding as to where you can reasonably make assessments as to the likelihood of finding illegal narcotics. Your affiant has been employed by the Kandiyohi County Sheriff's Office since 2013. Since 2018, your affiant has been assigned to the Detective Division on a full-time, next one, full-time basis, focusing on felony level crimes, including but not limited to criminal sexual conduct, homicide, death investigations, missing persons, fatal motor vehicle crashes, burglary, theft, harassment, stalking, assaults, controlled substances, child sex abuse material, and financial crimes. From 2013 to 2018, your affiant, again, this is the police officer who's signing off and requesting a search warrant, self-attesting as to his own credentials, was assigned to the Kandiyohi County Sheriff's Office Patrol Division for investigating street-level crimes, including but not limited to driving under the influence, controlled substance crimes, thefts, burglaries, assaults, financial crimes, frauds, and domestic violence. From 2010 to 2013, your affiant was employed as the chief of police for the Sacred Heart, Minnesota Police Department, which include responsibilities of administration, investigations, and patrol. Your affiant has attended hundreds of hours of training, including but not limited to crime scene investigation, property crimes, criminal sexual conduct, criminal interdiction, assaults, domestic violence, hate crimes, child sex abuse material, active shooter, death investigation, aquatic death investigation, elder abuse, vulnerable adult financial abuse, financial crimes, firearms, less lethal munitions, diversionary devices, chemical agents, cellular phone extractions, cellular tower investigations, and evidence collection. Certainly seems like it's a pretty full resume that Officer Pomplin has. Your affiant is certified in firearms instruction, SWAT team leader, cellular phones, technology mapping analysis, less lethal munitions instruction, flash sound diversionary devices instruction, chemical agents instruction, DMT operator, boat and water ATV, snowmobile safety operator, Glock armorer, Alice instruction, and former drug recognition evaluator. So there you go. There you have a resume for Officer Pomplin and why he is a satisfactory individual to make assessments as to whether or not there may or may not be illegal items located in the premises to be searched. Case background. On May 16th, 2024, Kandiyohi County Sheriff's Office Sergeant Dave Nestor received a report regarding possible child neglect and controlled substance use. The reporter indicated that Nicholas Rekieta resides at, and he gave his address, in Kandiyohi County. He resides at this residence with his wife, Kayla Christine Rekieta, giving her date of birth, and 5 children ages 6 to 16. The reporter indicated that 4 people from their church had gone to him reporting neglect to the children, possible controlled substance use, and questionable relationship with an additional couple. Okay. So, again, he's trying to establish that there's a reasons, probable cause that he's going to find drugs on the premises. It was reported that Nicholas is a social media blogger, and he and his wife Kayla and had befriended hosts from a different local social media blogger. Those individuals were identified as Aaron Michaels Imholte and April Diane Imholte. Your affiant knows personally these are personalities of the Steel Toe Morning Show, which used to be in St. Cloud, Minnesota radio. I don't know how he knows that personally, but I don't know if that means he knows the Imholtes, or if it means that personally implies that he knows them personally, not just that he's watched some of their work. However, as of recent years, the show has been a social media entertainment show strictly online based. It was reported that the Imholtes may have been staying with the Requietas and the home was in disarray and cluttered. He doesn't say exactly where it was reported, but that's reports he's claiming to have received. It was reported from a church preschool teacher, okay, that the children had complained. That's not good. So the preschool teacher purportedly said that the children had complained of being hungry, not being fed, and wearing the same clothes for 3 to 4 days at a time and would start to smell. Nicholas was reported to being lethargic and apparently high or drugged driving a car around. Another individual advised the reported that Nicholas will walk out randomly during sermons at church and have noticed behavioral changes in him. Now, some of these facts that they're alleging in here, you wonder how that's really relevant. I guess some would say that with respect to the child neglect, obviously the preceding sentence, if true, is would be concerning to most people, you would think. If I heard reports about someone saying things like that, I would think that most of us would say that's something that people would raise an eyebrow over. Another individual advised that the reporter that Nicholas will walk out randomly during sermons at church and notice behavioral changes in him. That obviously is less direct as far as there being any relation to any illegal activity. It was alleged Kayla looks anorexic and Nicholas has lost a substantial amount of weight recently. One individual described Nicholas of having injection or track marks on his arms. The reporter reiterated concerns for possible neglect and or controlled substance use within the home. Which, again, just the idea is they're trying now to establish, Officer Pomplin is trying to establish that there's a reason to search the home and believe that these are in his home. And now you have someone expressing concern. It's unclear, at least so far, what the basis of that is with respect to why it would be in the home. Although, to be fair, one would assume that that's a common place for someone to store their drugs. Your affiant started to review the Requietas and Imholt's social media blogs. The blogs are commonly related to legal issues and high profile trials, as Nicholas is a licensed attorney. Nicholas is known to drink alcoholic beverages on these video blogs. I immediately noted that Nicholas's appearance in recent months has changed. In videos from January 2024 compared to May 2024, Nicholas appears to have lost weight, appears tired, and overall appears, quote, strung out, common with controlled substance users. So the reason he's giving this whole description of the change in Nicholas's appearance is to indicate that over the last 4 to 5 months, it seems as if he's been engaging in illegal drug activity just based on common appearances. And again, this is an affiant who seems to have experience in making these assessments. Nicholas commonly refers to his studio as his basement in his own residence. Nicholas has been the victim of swatting phone calls and is known to your affiant and the Kandiyohi County Sheriff's Office because of these calls. When the Kandiyohi County Sheriff's Office responds to his calls, they were at, and they assume they provide his address. While reviewing Imholte's social media video blogs, Aaron recently indicated that he and April are getting a divorce. Aaron goes on to say that he has experimented with cocaine 3 times and Molly 6 or 7 times in the past recently. On December 19, 2023, the Imholtes broadcasted a podcast from Rekieta's studio, with the podcast being named, quote, Live from Spicer, STES 12/19/23. Throughout Imholte's video blogs, it is apparent that they and the Requetas were friends and may have recently had a falling out. It should be noted that in recent videos of the Imholtes, April has at times also appeared tired, lethargic, and strung out as well. In both Nicholas and Imholte's video blogs from Rekieta Studio, it is apparent they are in the same room, and the items in the background appear the same. At one point during the Imholte's video, Nicholas walks in the background and grabs an item, which would show that the background is not a backdrop curtain and that it was the layout of the actual room, meaning it wasn't some sort of green screen that's meant to look like Nick's house, but that it seems as if Nick was actually there with him. It's not clear what activity happened on this stream from the time they talk about 12/19/2023. It's not clear what happened on that stream. We definitely see Aaron admitting that he's used cocaine 3 times and Molly 6 or 7 times. It's unclear to me what's in this stream, but on 5/22/2024, Imholte did a video blog where he talked about Nicholas and insinuated controlled substance use, and also referenced a video blog that Nicholas put online on May 21st, 2024, that had since been taken off the internet. Imholte indicates in this blog that Nicholas needs help, and he needs to get help for kids because of his substance abuse. Holte points out a time in the video where Nicholas has a white powdery substance on his nose. On May 22nd, 2024, your affiant was able to review the video that was taken off of Nicholas's YouTube and Rumble social media sites. The video is from May 21st, 2024, and is of Nicholas in his basement studio talking about a Court of Appeals ruling he lost. He appears in the video to be drinking alcoholic beverages and eventually appears under the influence of a substance or substances. This is a day or two prior to the to this application being made. The entire video blog is 4 hours and 4 minutes long. Approximately 2:46 into the video, Nicholas leaves to go use the restaurant. When he returns at 2:40, I don't know what that means. Is that 2 hours later? Is that 2 hours and 45 minutes later? He appears to be making an excited look and has white powdery substance on his nose. Your affiant believes his behavior is indicative of central nervous system stimulants. Your affiant believes, based on training and experience, as well as the behavior of Nicholas, that he ingested this white powdery substance through his nasal cavity while off camera. Your affiant knows through training and experience that ingesting controlled substances through a nasal cavity is common amongst controlled substance user and is often referred to as snorting. Your affiant also noted that throughout the video, Nicholas is so under the influence of a substance to the point he has to close one eye to read his screen, rambles and slurs his speech. Nicholas would obviously not be able to care for his children in this state of intoxication. It should be noted that your affiant was a drug recognition evaluator for several years, and based on your affiant's training and experience, the behavior of Nicholas in his video blog indicates polysubstance use, meaning more than one substance. Meaning we believe that he was ingesting more than one substance based on his behavior, being both excited and nearly passing out. This can be consistent behavior of using both CNS stimulants and depressants. Your affiant believes that the reports of neglect and controlled substance use are consistent with the previously mentioned information. Your affiant is requesting to search the address for the above listed items in relation to the welfare of the children in the home and in relation to a controlled substance investigation. Your affiant, so you see here, they're not just asking to check on the welfare of the children, but there's specifically a request to do further investigation for controlled substance. Your affiant is also requesting to search Nicholas Rekieta. That is the application. So, at this juncture, based on what is averred to here in the affiant's application, we have to ask ourselves, as we come back and look at the law yet again, what the standard is yet again, and that is, do we think that this has met a burden, a sufficient burden that no court would overturn this warrant? Or I shouldn't say no court, but that it seems unlikely that a court will overturn it. And this is what we see. Again, this is reviewing the law. We just went through all the facts. Let's just go through listing verbally the facts that were attested to. There are claims from some people that the children are their claims purportedly from a preschool teacher. And again, I want to be clear. All these claims that are being presented, I certainly want the public to remain aware of the fact that these are all these are allegations that are made by folks. And this individual who's signing this affidavit is swearing that these are allegations that were made. Those allegations could have been made by anyone, could have been by people who are well-meaning. It could have been made by people who are very, very not well-meaning. We don't know. We don't know anything about that. What we do know is that there were allegations that were made, and this affiant is swearing that these are allegations that came to me. These are allegations that came with respect to the welfare of the children, with respect to their clothing and their food and general hygiene. There's allegations that were brought to us about there being various appearances of Nick that are consistent with illegal drug use. Some people saying that he was driving around without drugs, with where he appeared to be lethargic. These are the claims that are being presented to the judge. In addition, now you have this person who seems as if he's implying that he has certain levels of expertise and training and experience and understanding what it and in assessing individuals who have taken narcotics, saying that he watched Nick's show on May 21st and saw various things in there, which in his assessment indicate that while he was in his studio, in his own house, in his basement, that he thought that, based on his assessment, that Nick Rekieta was on multiple drugs. Based on this, the question is the warrant appropriate? Should it be issued or not? This is the warrant that ultimately was issued in this case. We'll come to this. We'll wrap this part up first before we get back to the law. And then we'll look at the search warrant that was signed off on, and then we'll review the law yet again. So Quinn Pomplin said, I request a search warrant to be issued commanding Quinn Pomplin, Robbie Barnes, Nick Ardoff, Dave Nestor, Rob Twett, peace officers of the state of Minnesota, and any other authorized person to enter and search between the hours of 7 a.m. and 8 p.m. to search the above described premises and persons for the described property and things, and to seize and keep said property and things in custody until dealt with according to law, including authorization to have seized property and things to be analyzed by a forensic laboratory. I declare under penalty of perjury that everything stated in the document is true and correct. So now it's sworn to by the applicant, Quinn Pomplin. And here's the search warrant that the judge issued. This is what it says. After she read through that, Judge Fisher issued this search warrant. Whereas Quinn Pomplin has this day, under penalty of perjury, made an application to this court for warrant to search and find described premises and persons. The resident has, and go through that entire residence. Whereas the application quin pomplum was duly presented and read by the court and being fully advised in premises, now therefore the court finds that probable cause exists for the issuance of a search warrant upon the following grounds: possession of property or things above described constitutes a crime, and the property or things above described constitutes evidence which tends to show a crime has been committed or tends to show that a particular person has committed a crime. The court further finds that probable cause exists to believe that the above described property and things is or at the above described premises and on the person of Nicholas Robert Rekieta, giving his date of birth. And the warrant concludes with, now therefore, you Quinn Pomplin, Robbie Barnes, Nick Arduff, Dave Nestor, Rob Twett, peace officers of the state of Minnesota, and any other authorized persons are hereby commanded to enter and search between the hours of 7 a.m. and 8 p.m. to search the above described premises and persons for described property and things, and to seize and to keep said property and things in custody until dealt with according to law, including authorization that seized property and things be analyzed by a forensic laboratory. By the court, Judicial Officer Jennifer K. Fisher, Judge of District Court. So that is the order. Now I'm going to turn to you and ask you to assess. Do you think that this order was justified under the law? Let's review what the law is over here. In Illinois v. Gates, the Supreme Court ruled that the presence of probable cause should be determined under a totality of circumstances test. The task of the issuing magistrate is simply to make a practical, common sense decision. Common sense, given what she was presented. Everything that we read in that affidavit. So, did she make a practical, common sense decision, whether given all circumstances set forth in the affidavit before him, including the veracity and basis of knowledge, meaning if there were persons there who seem more trustworthy or less trustworthy? One of the things identified in there is that perhaps a source here, I don't know this to be the case, but that perhaps one of the sources there is someone who might be upset, have issues with him, in Aaron Imholte. It's not clear whether or not he's one of the people who helped support this claim. I don't know. Maybe he did, maybe he did not. It certainly seems they reference implications that there was a falling out, which would lead to questions about his particular veracity. For the purposes of assessing the credibility of what's been told and what's been learned by this officer, Officer Pomplin, it seems as if there were multiple people here who had made claims. In addition, he had his own visual confirmation of some of these claims based on his review of videos going back 4 months and seeing changes in physical appearance, as well as the video of May 21st, where he drew conclusions, rightly or wrongly. Again, just because he drew those conclusions doesn't mean his conclusions are correct. But what we're trying to assess here is, would a reasonable person say totality of circumstances justifies the issuance of a warrant to search his home? Is that a reasonable conclusion based on totality of circumstances? A person supplying hearsay information and there's a fair probability. We're looking for a totality of circumstance that there's a fair probability that contraband or other evidence of a crime will be found in a particular place. That's what we're looking to see. Totality of circumstance that there's a fair probability that contraband or evidence of a crime will be found in Nicholas Rekieta's home. So based on what we saw, do you think that the judge made a terrible call? That it was a crazy call? Do you think that it was the right call? Even if you think it was a right call, even if you think it was not the right call, unless we have to give great deference to her call on this. And after reviewing court should not review that determination de novo, but we have to say, okay, she made this call now. Was that crazy call to make? And based on that, only if we say that it was a crazy conclusion for her to draw that there's a fair probability of contraband in Nicholas Rekieta's home, that's where the search warrant will be overturned. Again, I want to be clear. There could be case law that's very relevant. Could be facts that are very relevant, that the case law would be unknown to me and the facts would be unknown to all of us, which could shift the entire dynamic as far as assessing whether or not this search warrant appears to be valid and will withstand scrutiny. It could be very important cases that just flip everything on its head. This is just an overview as to what Minnesota law is in general and what we see was presented before Judge Fisher in trying to assess whether or not it's likely that her decision to issue a warrant will be overturned by an appellate court. Fourth Amendment requires only that the magistrate had a substantial basis for concluding search would uncover evidence of wrongdoing. Now, you might not like that law. You might think that's wrong or that's a violation of the Constitution. But that is the law, and we all operate within the law. That's the world we're living in. In reviewing the sufficiency of an affidavit on totality circumstance, courts must be careful not to review each component in isolation, but just overall totality of the circumstances. Even if each component is judged unsubstantial, the components viewed together may reveal the informant's tip and internal coherence that gives weight to the whole. Now, if we look at everything together, it makes us come more likely to a conclusion that there's a fair probability that contraband or evidence of a crime will be found in Nick's home. Furthermore, the resolution of doubtful or marginal cases should be largely determined by the preference to be accorded warrants. When we look at all of this, we look at all of these factors, I will tell you in my independent assessment here, when I look at the law and we look at what was presented to Judge Fisher, based on what we know so far, it seems difficult to understand how this warrant will be overturned. My personal assessment. That doesn't mean it won't be. I'm simply saying the reality is that given the state of the law and the affidavit there, which I think a lot of people would conclude that if you're talking about someone that you didn't know and you heard that's what was said about them, you would say, yeah, the court should issue a search warrant there. Now, a lot of people will question, what if they were completely lied to? What if all of it was completely bogus? I can't tell you how that would play out. I have thoughts about that. I'll share that on Locals afterwards, my thoughts on that. I can't tell you how that would play out, whether that would be, I can't tell you definitively how that would play out. But in theory, every word in that could be complete garbage. Could be. I mean, people saw what they saw with respect to the May 21st video. Every word could be garbage. He's innocent until proven guilty. Right now, the reason I went through this assessment is just to assess the likelihood that this warrant will be overturned. And based on the law that I've seen so far, and there could be other law that would completely change my analysis, based on the law that I see so far and the facts that were presented to Judge Fisher, to me, it seems unlikely that this warrant is going to be overturned on constitutional basis. That's my personal assessment. Let's go forward and see what was found in due course. I think most of this we've seen already, but can't hurt to review. Oops. Receipt, inventory, and return. Detective Quinn Pomplin, Judge Jennifer Fisher, May 22nd. Pursuant to the warrant on 5/23/2024, 9/13, I searched the filing described in the search warrant. I took see the attached lists. What do you got on your attached list here? You have to receive for property and things listed above the copy of the warrant. And this is what he found. Page 1 of 3 pages of findings. First one. Done. As we see, Officer Pomplin may have a great deal of experience, but not with penmanship. I'll tell you that. Found 1 snort tube plus cocaine. Master nightstand. 1 bioquil white substance. A black Vic white substance. Okay. 2 red if cards after April. Oh, two credit cards. This is a C. Two credit cards belonging to April Imholt that was on the nightstand. 222 spent casings from the nightstand. Sig Sauer AR with the serial number plus mags in the master bedroom. Glass container plus metal container shall we in the dresser in the master bedroom. One bag with cards. Wow. This is, I'm going to assume that Officer Pomplin was in a big rush when he wrote this. One long, what is this? Long Croter cut. One large cut white powder. Master bath. A baggie with pipe. Ziploc. Baggie safe master bathroom. Ziploc with multi-shell white powder. Okay. I don't know what we get from this other than seeing that Officer Pomplin has abysmal handwriting. Digital scale, metal pan, two short tubes, $100 bill, Bindle Bass, white substance, scooper from master closet, two baggies in baggie with funnel, master bedroom, Springfield Armor number 45, armory, Sig Sauer 380 handgun. These are in the garage safe. Magazines with ammo. Okay, and there you go. That's what they found. Now I know that they also say they found a brown substance. People are speculating about what that is. As of right now, there's no reason to assume it's anything illegal in the state of Minnesota. So I'm going to assume that it is nothing illegal. As you're aware, that collectively, that the threshold to move up from a level 3 charge to a level 2 charge is the weight of the combined weight of the narcotics, which from what was reported is 26.7 grams, and the cutoff threshold is 25 grams. I can't inform you as to what the law is in Minnesota if some of those grams were some of those drugs were cut, meaning that there's an additive that's not illegal that's thrown in there, which may reduce the overall weight of the illegal substance below 25 grams in the baggies and things of that nature. But as of right now, he's being charged with having 26 grams, and that can have penalties in theory of up to 25 years, with sentencing guidelines that imply that it certainly could be for 4 or 5 years. That is what he's facing right now. Anyway, that's the law and the facts as I see them right now. This was an analysis of the search warrant, the validity of the search warrant, based on what overarching themes of Minnesota law is, together with what the affiant presented to the court. And again, based on how I read it, I think that there will be a struggle for a defendant in this type of circumstance to establish that to get this warrant overturned as being unconstitutional. And there could be other factors that will play in, but I'm being real with you as to what I see here. I'm going to go through some super chats, and then I'm going to close out here, and I'll give you some additional thoughts over on locals. Hey, your last week was so moving and caring. You seem to be a really good man. Great to be back. Peace and blessings to your family. Thank you. We've missed you, Republic Room. It's good to see you again. Here are some shekels for not taking advantage of the situation for clout. Ironically enough, Herder, he's profiting off Nick's demise. Herder? I don't know. Herder, he's profiting off Nick's demise. Okay. Sure, Joe, it'd be nice to get Nick off on some technicality, but Nick's hypocrisy is where I draw the line. Hope it's not a strategy. Hope is not a strategy. Move on, Joe. Well, you wrote that at 410. So I think my objective is to present as realistic an analysis of the law as possible. And I don't think anyone would take my analysis here, as something that Nick was really that is nose guarding, as they say. Little Rock says, "Let me lay out the affidavit." I'm going to give you one of these for all three. A pastor appointed 4 members told him Nick looked bad. A preschool teacher, who could not be in any of the children's teacher, said that the kids reported being dirty and hungry. Okay. All the kids had looked dirty or said they were hungry right after they had eaten. This expert cop determined drug abuse watching a guy get drunk on camera. Determined drug abuse watching a guy get drunk on camera. True. All true. And I think you're making fair points here, Little Rock. Little Rock is an attorney. And he's making fair points. Okay. Yeah, the affidavits also. Question is, as far as you're saying that because it's on camera, so that won't count as evidence. He explains how the studio was in the house. I mean, we're not looking to prove that he's guilty beyond reasonable doubt in this affirmation. We're looking to see, does it seem more likely than not that they're going to find drugs if they go into the house? I'm just saying, like, being reasonable, if you're presented with this set of facts, and I ask you, if you go into that house, do you think you're going to find illegal drugs there? Here's all the facts that were presented. I'm just trying to, I'm being real. I'm trying to be as realistic as possible as to whether or not I think some appellate court would say that this is too far a reach for this. I'm not even assessing whether or not she was right. I'm simply saying, will an appellate court overturn this search warrant? And based on what the case law in Minnesota seems to be, I think that's highly unlikely. I'm not trying to justify and say it should have been given. I think a lot of people listening to that would say that it should be given. I haven't even thought about that. The question is whether it should be overturned at this point. That's the analysis I'm looking at. And what I'm saying is, I don't see how, based on the law that I've read, this should be overturned or will be overturned. And there could be other law that I'm unaware of. There could be other facts that I'm unaware of. That could change the entire calculus here. Simply saying what we know today, May 28th, as of 4 p.m. on a Tuesday. This whole thing is bogus, should be dismissed on the basis of cops not talking about what they did with the ball. Where is it? Did they have to touch it? Finally, I've been watching you, Nick, and other law tubes for a while now. I've seen a problem I perceive from Nick. I think Nick probably needs to get in rehab for alcohol alone. Yeah. Yeah. I hope he does get it. I hope he goes to rehab. Bach Prethion, thank you for the super chat. Joe, this is sad. Another 40-something SASTer covering for LBJ quote fulfillers. You couldn't make the grade on my Discord server, you camaraderie seeker. Okay. Ingestion is to eat, imbibe is to drink. Insufflation is to snort. Is it really insufflation? Thanks. If the presence is heroin, what would that mean for sentencing? I don't know if there's any claim of heroin. I haven't heard any legitimate claim of heroin. I heard one YouTuber speculating that maybe the brown stuff is heroin. I think that's a ridiculous assumption at this juncture. Maybe they'll test it and prove it to be heroin. I'm simply saying at this juncture, I think that's such wild speculation that it's. I would certainly never venture there. Your affiant newspeak for Karen. Fair enough. Joe, even if the search warrant is overturned, there's plenty of allegations in the affidavit itself to justify charges. I think without evidence, I think that this case, I'm not saying the charges would go away without the evidence. I simply think that the charges they're in air without them. I don't see how this evidence is going to go away. So I don't think a court is going to say that this search is has to be overturned based on what we see so far, based on what we know so far. And again, I'm not a criminal defense attorney. I'm not a prosecutor. I'm telling you what I see here. Good to see you, MLS. Nick ruining LawTube friendships as well as him. I don't think he's ruining any LawTube friendships at all. But for the grace of God. But would you want a child killer free on a technicality? Nick needs tough love and rehab. I agree. I agree. I agree. I want to see him get rehab. I want to see him get better. I'm not close to Nick, but anyone who watched the channel could see that his life was spiraling out of control. Joe, did you try to help him? Yes. I'm not sure when you say spiraling out of control. I'm not sure what you mean with respect to like Joe. Did you try? I have tried to help Nick. Yes. A lot of people who are close friends of his, have genuine interest in his well-being. There's some people out there who I would say chasing clout. Other people out there who are interested in his well-being. I'm certainly not going to name names and say this person belongs here and that person belongs there. But yeah, he is a pretty nice cadre of friends who genuinely care about his long-term well-being. And I'm proud to number myself amongst them. If you were the judge, what would your sentencing be for Nick? Impartial, of course. I could not possibly sentence at this juncture. We don't know enough. He's innocent. Right now, my sentencing would be go home. You're free. Because he's innocent in the eyes of the law until proven guilty. So I don't know. We don't know anything about Nick's side of the story yet. Nobody knows anything, nor should they. No, I want you to know something. I want to see Nick really talking as little as possible about this. I know he's in a crazy position, but I don't want to see him talking. That's what, if he was my client, that's what I would say. Don't talk. Don't talk about anything about this case. And it sucks that people who hate you are spewing off in the mouth and spreading all this stuff about you, and you're basically left mute, kind of like Trump. I understand that. But this is what you got to do right now. This is what he's got to do. That's what I hope he takes that advice. I want him to shut up. Shut up. Go for rehab. Get your lawyer, go for rehab. And just course correct. It's not easy. I'm not saying it like it's you'll just like flip a switch and everything is good. But it starts with a couple of steps, right? I believe one of the children made a complaint to the pastor. The pastor then took it to the police as the conditions in the household were not kosher. No one knows that. No one knows that. That's not what even was. I'll tell you this one. I don't believe that happened because they identified two separate people, pastor and a preschool teacher. So I don't understand. So I don't know. So if anything, there would be a complaint to a preschool teacher. If anything. And I'll tell you this much: I don't know. I can't even wait on that. The whole thing smells like personal vengeance. Nick stepped on someone's toes and ratted him out. The question is whether they ratted him out truthfully or made up crap about him. That's really what ultimately boils down to, right? Your rabbi's next drasha, you better sit there. I know. I thought this is like when he's saying a rabbi's sermon. I thought that was such a weird thing to put in there that he walks out of church in the middle of a sermon. I guess they're trying to show his inability to control himself. Maybe the sermons are really terrible, boring. I don't know. Lesko says Nick really doesn't drink that much if you watch him. Which is what confused me. But now we know where the insane intoxication may have come from. Possibly. Big Red Snake says, I wish him well and get away from this. Why be loyal when you're below 100K subs? Nick was LARPing, but he's a sicko, swinger, drunk, and druggy. You're involved in politics now. You need to be getting away from this. I was simply giving my assessment as to how I understand Minnesota law based on the fact and applying that here for the benefit of the audience, who many of whom probably came across this search warrant. And I'll tell you right now, I think a lot of people assumed that I was going to look there and that I was going to be falling in a camp that's going to say, "Oh yeah, this is garbage," and Nick is, this is totally hot garbage, and you haven't seen me say anything of that kind during this stream because my opinion is I think this is legitimate. I think it's a legitimate search warrant. It's my personal opinion that if I was a judge and someone came to me with this affirmation, I could very I've never been in that circumstance, but I could very well see signing off on that. So I could be wrong. I'm just telling you that's what my read is. Little Rock's gonna tell me how wrong I am. I've had strong affidavits than this thrown out on appeal. Okay. This is all on hearsay without follow-up. The cop followed up none of the four church or YouTube guy or the church. So this is an interesting thought. And I respect your opinion. Again, Little Rock here is an attorney. And it's very possible you can sway me into thinking that this is wrong. I'm telling you, I walk into this stream thinking this sounds okay, and you're telling me that you've had stronger affidavits than this thrown out on appeal. And okay, I appreciate you know, I'm simply saying you look at the wide berth that's given to a magistrate's findings. I'm telling you, I don't know that I would have rejected this. Maybe I would have accepted it. Maybe I would have rejected it. I don't know. It's very hard to know when you know that it's someone that it's affecting you. You sort of have to recognize sometimes that your own biases get in the way of your ability to assess something completely removed from it, right? So, and we're all suspect to that. Every one of us is suspect to that. If you weren't, you don't have any heart at all. So it's impossible for me to just say, okay, but I'm doing my best to try to step out of my own shoes. And I think that if I stepped out of my own shoes here and you just told me this about, random Mr. X, I'd be like, yeah, I think it's probably likely you're going to find drugs in his house. I think I would come to that conclusion. So I'll admit to you privately, this Joe. This tore my stomach up when I heard about it. I don't know why so much. I've never met Nick personally, but I felt bad for him. Yep, I can relate. It's more than just cocaine, alcohol. The I am board certified addiction. I sent Nick my contact info. If he wants to help, he just needs to contact me. He needs to want it, ultimately. I think he does. Preschool teacher for kids age 6 to 16. Yeah, I don't understand that at all. That was very suspicious. That was suspicious. I agree with you on that. I don't believe they have a preschool teacher, which makes you question the entire thing. Like, what the heck is a preschool teacher for a 6-year-old? Sorry, but this guy from Minnesota, Barnes is right. Okay. Okay. I'm not arguing for Nick. I'm just doing legal analysis and how I would go about it. As a defense attorney, I could lose too. Yeah. Thanks for responding to my email. I appreciate it. You're welcome. Thank you for not jumping on the bash Nick wagon. I'm certainly not bashing Nick at all. I think that I don't think I know that he's innocent until proven guilty. I am confident that a large part of what's in here is hot garbage. That doesn't mean that I disagree with claims that he needs to course correct. And course correct implies go to rehab. That's what I'd love to see for him. I'd love to see for him. I'd love to see him be quiet, go to rehab, take care of this, fix your life, fix your legal issues, go on your way. That's my personal opinion. It's not my life. Just telling you where I stand on it. I wish nothing but success for him because he happens to be an amazing human being. And I think that we'll see it. I'm hopeful that we will see it. That's the end of my show here on YouTube and on Locals. I'm going to be shutting those down right now. I'm going to continue. Sorry, not Locals. That's on YouTube and Rumble. I'm shutting down YouTube and Rumble right now. I'm going to be going over for a brief bit over on Locals. Not very long. But that's what I have for you with respect to my assessment here. And I will be back, God willing, tonight. Please make sure while you're here that you like and subscribe. It's very important as I'm marching closer and closer toward 100,000. Trying to get to that 100,000 over here. Over on Rumble, I'm trying to get to some number that I'm not at yet. And feel free to click the link in the description, in the chat, if you want to join me for the balance that will be covered on locals. There you go. If you haven't hit subscribe yet, I don't know what to tell you. Please hit it now. I will see you all tonight. Thank you very much. Have a great day. And as always, my friends, I say to you on YouTube and on Rumble, Godspeed. Those folks in local, stick around.